Further hearing the appeal of McCulloch and others against Hall Valley Health Board.
Ms. Doherty.
Yes, my Lord. Yesterday, at the end of yesterday, some questions were asked about whether the Inner House were asked to make findings in fact, and I said that they hadn't been. Now, I confirm that in the Inner House opinion, at paragraph 24, and it's found at page 202 of the bundle, so paragraph 22, the Inner House note the grounds of appeal, and then at paragraph 24, the Inner House state that it's important to note that, save to the extent suggested by the second part of ground 1, and that was that had the Lord Ordinary made a finding in fact that the deceased presented with pericarditis and worsening pericardial effusion in practice and not prescribing non-steroidals could not be supported. So apart from that, the appellants do not assert that the Lord Ordinary erred in making any particular findings of fact, nor do they assert that he should have made alternative findings of fact, despite asserting in grounds 1 and 4 that he erred in his assessment of the evidence. This court was not asked to make any findings of fact. My Lords, the appellants did ask the Inner House to find that there was a duty to prescribe non-steroidals, and if they had been, Mr McCulloch would not have died. So they did ask the Inner House to reach this conclusion without asking for specific preceding findings in fact. And as was noted, I think, yesterday, in the Inner House statement of reasons not to allow permission in the appeal, and that's found at page 194 of the bundle. Paragraph 1 of that, Lord Pentland, who delivered the reasons, noted as a preliminary matter that the applicants do not contend that the Lord Ordinary erred in any of the factual findings that he made, nor do they propose that any additional or alternative findings of fact should have been made by the Inner House. So there was no criticism there, it seemed, of any failure by the Inner House to make findings of fact.
But without findings that ibuprofen at a certain dosage would achieve a reduction in inflammation and diminish the effusion, how can one reach the conclusion that the Inner House was asked to reach?
Well, exactly, my Lord.
Do you say the Inner House made a finding on causation itself?
The Inner House did, my Lord, in their decision at page 207, 208 and 209, they examine all the evidence about the use of non-steroidals. And I'll come on to this in the next part of my submission. And they looked at that and then concluded that the Lord Ordinary was entitled to reach the conclusion that Dr. Bloomfield's evidence was not unreasonable or illogical. What they say in particular at 45.1, which is at page 207, and this is a matter which the appellants do appear to criticise in their case. They state at the end of 45.1, and that's in the second column of page 207, essentially the literature does not seem to support the assertion that non-steroidals have a benefit beyond pain relief. And then another important part of their consideration was at page 208, and this was 45.6, when they consider whether there was any evidence that non-steroidals were effective not only in treating pain but in reducing the size of an effusion. And then at paragraph 45.7, they look closely at the evidence of Dr. Flappin, which the Lord Ordinary was not impressed by, and they said at page 209 that they'd read that passage of evidence themselves and they could understand why the Lord Ordinary wasn't impressed by that evidence. So,
yeah, and they return to this in page 194, paragraph 3, again in the reasons given for refusing permission. Paragraph 3, the applicants failed to prove that non-steroidal anti-inflammatory drugs were capable of bringing about resolution of a pericardial effusion. So that's a logical step anterior to any conclusion on the facts of this particular case, but
yes.
They'd have to be capable of working
yes.
in the first place.
And they say that really at paragraph 60 of the decision, when they say in respect of non-steroidals, and that's at page 212, we can see no basis upon which the pursuers could have succeeded. The list of issues affecting this aspect of the case are summarised at paragraph 46, are relevant. So,
and they say at page 195 that they're addressing the issue of causation at the end of paragraph 4.
yes, their view was they had addressed causation, and they referred this court to paragraph 60 of their opinion. It was clearly their view that non-steroidals would not have had the effect that the appellants say they would. I don't want to take up more time really with this, my lords, but just before court this morning we've received intimation of the note of arguments that the pursuing reclaimers had before the inner house. I presume that's been provided to the court as well?
Not so far.
I'm not aware of it.
Okay. It was just
sent electronically to the registry this morning.
It's probably on its way.
well, just to say that having looked at that, again, there is reference in that at paragraph 8.7 that says the Lord Ordinary should have made a finding in fact that had a repeat echo been performed that Mr McCulloch wouldn't have died. Of course, we're not involved with that case now, but I would just point out that they didn't ask for any necessary findings in fact to enable the court to reach that conclusion. They didn't ask for findings in fact about when such an echo would have been taken, what it would have shown, what would have happened then. They do deal with non-steroidals in this note of argument as well. At 8.22, they say the Lord Ordinary failed to take account of evidence that treatment with non-steroidals would have prevented the death. And as I say, they did ask the Inner House to reach the conclusion that non-steroidals would have prevented the death, but they didn't ask for a specific finding in fact about the efficacy of non-steroidals. So if I can move on, the other thing which I think will be coming to the court is a list of authorities which my learned friend intimated this morning, again just before court. If you don't have it, I won't address on it now, apart from very briefly. There are 7 authorities listed, and this was because I think my learned friend said yesterday he would provide the court with a list of authorities where Drake was referred to.
Oh, yes.
Yes. So it's a list of 7 authorities. From our very quick look, and that's all we've been able to do this morning before court, only 3 of those authorities seem to mention Drake. It's number 3 in the bundle, which is a Court of Appeal decision. Number 5 in the bundle, which is not a Court of Appeal decision, and number 6 in the bundle, which again is not a Court of Appeal decision. But from what we've been able to see so far in our short time, these decisions all appear to support our position that a common sense approach is taken to the evidence. So it doesn't change the submissions I made yesterday about Drake.
Yes, well, on one view, Drake is merely saying the facts speak for themselves, or given that this is a Scottish appeal, I can use the Latin phrase, res ipsa loquitur.
So, that's taken some of my allocated time for this morning, but I felt I had to clear up those things because they did arise yesterday. So at the end of yesterday's submission, I've been talking about the legal framework.
Just before you go on, can I just ask, do we have anywhere of grounds of appeal? We've got the application as item number 1 in the bundle, but it doesn't. It's simply the form. It doesn't contain the grounds, and I'm not sure if we have them anywhere else.
I
maybe
suspect they're not, my lord. I think they would have been in the appendix.
Oh, perhaps they're all. Perhaps that's where they
The
are.
appendix hasn't been produced in the bundle, I noticed.
We do have an appendix, but it seems to be materials from the courts that were before the courts below.
But I think the application to appeal, I think, would have a document attached to the back of it called an appendix.
Well, it normally does, yes.
And that's what doesn't seem to be produced in this bundle, I'm afraid.
It might be, perhaps, Mr. Weir, you could deal with that. It would be helpful for us to have the grounds, obviously.
No, but that's before the inner house. Is it the grounds of appeal before the inner house, my lord? Or
No, before this
house?
court.
Yes, that's what I thought, and I don't think they're in the electronic bundle we have before us just now.
Yeah, well, we ought to have them, but Mr. Weir and those assisting him can deal with that.
Okay. Right, my lords. So yesterday I was talking about causation, and I had finished talking about Shembry, which is discussed in the respondent's case at paragraph 72 at page 153. In the respondent's case, I then go on at page 154 to talk about McGee, and I don't intend to take my lords to McGee, but I do stress that this present case that we're dealing with is not a case where it would be impossible to prove causation on conventional principles. McGee and other cases in the industrial disease context are cases where it's impossible to so prove causation. And I would refer also to the respondent's case at paragraph 75, again that's at page 154, where the consequences of what the appellants contend the approach for causation should be. To infer in clinical negligence cases that a patient's condition would have improved with a particular treatment without scrutinising what evidence exists for such improvement is really akin to reversing the burden of proof as soon as breach of duty is established. Now, in the respondent's case, there's then a section about burden of proof, but given that the applicants have confirmed they do not seek a formal reversal of the burden of proof, I don't refer further to this section. I do stand by what's said there. So in conclusion, it's clear as a matter of law that the burden of proof remains on the appellants to prove in a balance of probabilities that the outcome was a result of the alleged breach of duty. Now, applying that law to the present case, as set out in the respondent's case at page 156, paragraph 80, even if an approach in Drake is followed, the problem with the appellants here is that death was not a loss likely to have resulted from the alleged negligence to allow an inference to be drawn that the negligence and the death were linked. There was another explanation for Mr. McCulloch's death in the evidence. He was ill and non-steroidals would not have treated his condition, and the appellants failed to prove that non-steroidals would have resulted in survival. Now, I've already referred to the various steps in the causal chain which the appellants require to prove to establish that advising Mr. McCulloch of the option of non-steroidals would have meant he would have survived. And at 81 to 107 of the respondent's case, that's at page 157 onwards, we set out why the appellants failed to establish causation, and I rely on what is set out there. Just highlight some aspects. Firstly, there would have been a hypothetical discussion about non-steroidals. There was no evidence of the content of such a discussion, of what Dr. Labinjo would have said, given that she did not regard non-steroidals as a treatment option. She did not think they were effective, and he wasn't in pain. She didn't think they'd be effective to treat an effusion, and he wasn't in pain. So I rely on what's said about that in the written case at 81 to 85. Secondly, there's the hypothetical decision. What is Mr. McCulloch likely to have decided, given her advice? And as set out in the case there, the evidence doesn't support that it's likely he would have decided that he wished to be treated with non-steroidals, despite Dr. Labinjo's advice that they were not an appropriate treatment. In their submissions and their case, the appellants rely heavily on Mrs. McCulloch's evidence to argue that Mr. McCulloch would have wished non-steroidals. However, as we set out in the case at 86, 87 and 88, that's at pages 159 to 160, what is asserted by the appellants is inaccurate and misleading, and it's important that this evidence from Mrs. McCulloch is put into its proper context, which is, in short, that the evidence they rely upon related to a different factual scenario and was not relevant to the causation issue now being considered. She wasn't giving evidence about what she thought Mr. McCulloch would have done had he been offered non-steroidals on the 3rd of April, when he was much improved and had no pain. And at 88 of the response case, at the end of that paragraph, it's at page 160, as we say there, the reliance on what Dr. Flappen had to say about this is misleading. Mr. McCulloch was not doing nothing to try to get better. He was being treated with antibiotics and was assessed as being well on the 3rd of April. So there's just no basis in this evidence from Mrs. McCulloch and Dr. Flappen to allow a finding that had Mr. McCulloch been told about the treatment of non-steroidals by Dr. Labinjo, which she did not regard as a reasonable treatment, that he would have wanted to seek such treatment. The third issue is whether they would have been prescribed and when, and we deal with that in response case at 89 to 92, and I won't deal with that because of time constraints. And then at 93 to 107 of the response case, so it's at page 161 onwards, we deal with the final necessary step in the causal chain, the efficacy of non-steroidals and whether they would have prevented the death. And the response position simply is that evidence doesn't support that. This was the view of the lower courts, and it is correct. And as we set out at the response case 95, at page 162, what the appellants present in their case about this at 93 to 107 is an inaccurate picture of what the evidence was and what the findings were. And more is said about how they do this at 95.1, .2 and .3, and my lords can read that for themselves, but I would highlight that much of what they quote relates to the standard case of acute pericarditis. This was not a standard case. And there was conflict in expert evidence as to the effectiveness of non-steroidals on effusion. There was no agreement between parties. There was no finding by the lower courts that non-steroidals would have made a difference to the effusion. And that's true even in the evidence led by the appellants at proof. There was a conflict in the evidence. The pursuers led two cardiologists as experts. The second cardiology expert, led by the appellants, Dr. Weir, had never heard of or considered the idea that non-steroidals could reduce the pericardial effusion until it was put to him in questioning. And he didn't agree that that would happen. Then, as we say in the response case at 96, page 162, the Inner House considered the issue of causation in detail as a critical part of deciding the issue about whether or not there was a duty to prescribe non-steroidals. We talked about that just earlier this morning in the context of did they make a finding about it. And as we've already looked at paragraph 60 of their decision, that's at page 212, the Inner House concluded that the primary reason for non-steroidals is pain relief, not any anticipated effect on the progression of the effusion. I do invite my Lords to actually to read fully the relevant paragraphs of the Inner House opinion at 45 and 46 and 58 and 60. But I have tried to summarise at the Respondent's case 105 the bullet points really that I would take from those important paragraphs of the Inner House decision. And nothing said by the appellants properly points to any error on the part of the Inner House. And I deal with that in the Respondent's case at 102 to 103, that's at page 164. And the appellants misrepresent in their case the evidence given by Dr. Bloomfield and its context. I set that out at 105 to 106. No, I don't. It's 103. I set that out at 103 and 104. So in conclusion, on causation, the Inner House were correct to conclude there was no basis upon which the appellants could succeed in their case based on the alleged duty to prescribe non-steroidals. The evidence doesn't support a finding by this court that non-steroidals would have prevented the death. And there is also insufficient evidence of the other preceding necessary facts for causation. What would the hypothetical discussion have been? What would have his decision been? What would have happened then had he wished non-steroidals? And then what would have happened when would he have actually got it? One final issue that was raised yesterday was whether this, depending on the court's decision, whether this should be remitted back to the Lord Ordinary. As is stated in the case, the Respondent's case, we see no purpose in remitting this back to the Lord Ordinary. The appellants had every opportunity to read evidence. They did so, including from 2 cardiology experts, and failed to prove their case. The Inner House considered the matter in detail as a critical component of whether there was a duty to prescribe non-steroidals, and found that their effectiveness had not been proven. Parties have referred this court to the relevant evidence in their statements of case and in their submissions, and in all these circumstances there should not be a remit to the Lord Ordinary. So in conclusion, my Lords, for all these reasons and the summary of reasons that I set out in the Respondent's case at 110 at page 167, for the Respondent I submit the appeal should be dismissed and the interlocutor of the Inner House should be adhered to. My Lords, unless I can assist further, those are the submissions for the Respondent.
No, thank you very much, Ms. Ardy.
Thank you.
Dean of Faculty.
Obliged, Lord. Lord, the General Medical Council seeks to offer such views as may be relevant in its role as regulator, and it is very grateful for the opportunity to address the court in this important case. At the outset, my Lords, can I recognise that the law of negligence and the regulation of the medical profession have different purposes. The former is there to provide redress for injury caused by want of the requisite care. The latter is there as a result of what statute describes as the overriding objectives. Those overriding objectives are found in Section 1 of the Medical Act of 1983, and they include the protection, promotion and maintenance of the health and safety of the public, the promotion and maintenance of public confidence in the medical profession, and the promotion and maintenance of proper professional standards and conduct for members of that profession. But acknowledging that these two areas of the law have different purposes, it is nevertheless desirable that they do not become wholly disconnected from each other. whilst it is of course dangerous to generalise, it would not promote the statutory objectives if doctors who failed to act in accordance with professional standards were deemed non-negligent, nor in general would it be helpful if doctors who have followed such standards to the letter were nevertheless found to have been negligent. Professional regulation and the law of negligence should, where possible, march hand in hand. Montgomery is, I venture to suggest, a good example of that. The guidance issued by the interveners was part of the reasoning given by this court for not applying Hunter against Hanley in questions of information as to risk. And professional standards have, of course, continued to evolve, and the 2020 guidance, which is before this court, was intended to update the profession in light of such evolution, including the learning from the judgments in Montgomery. And I should also indicate that standards will, of course, be reconsidered in light of whatever the court might say in this case. As the Council's interest lies in the promotion of good medical practice, everything I have to say, and there won't be much, is rooted in the Council's expectations of what good medical practice entails, having regard to the objectives I've mentioned, in particular, of course, in the present context, patient safety and maintenance of standards. Everyone accepts that the starting point for any given patient must be diagnosis. Everyone accepts that that is a question of professional skill and judgment. And as my Lord and the Chair remarked yesterday, diagnosis may often be unclear, it may be differential, and it may well change as time evolves. But it will always be a question of professional skill and judgment. And in a clinical negligence case, that means, and this is accepted at all hands, it's governed by the test in Hunter. But of course, that does not mean that the patient is disenfranchised, even at that first early step. In terms of good medical practice, a diagnosis needs to be arrived at logically, and that will involve collaboration and discussion with the patient, assuming, of course, he is sentient. A failure to engage in such collaboration might well lead to difficulties in defending the diagnosis. Now, of course, causation might become problematic if a negligent diagnosis turns out to be correct, but that doesn't change the fact that a diagnosis itself was arrived at negligently. If we
I suppose, Dean of Faculty, diagnosis itself is the outcome of a process which involves taking a history from the patient and carrying out the investigations which seem to be appropriate in the light of the patient's the impression the doctor has of the patient, the history given, and so forth.
Precisely so. And it's the patient-centred approach that is advocated by the Council that permeates everything that they do. And it is essential that the patient is the core at that from the outset. A doctor who walks into a consultation room and tosses a coin to work out what the diagnosis is going to find herself in difficulties.
May it also take into account the patient's reaction to medicines that have previously been prescribed?
Absolutely. Absolutely.
So it's an evolving, continual process.
It is. That's very much the point of the differential diagnosis, the diagnosis that may change as time moves on. But if we assume a properly arrived at diagnosis, the next question is how to treat the patient. And here again, everyone accepts that we are in the realms of the clinical judgment test. Thus, if we look at what's said in the Appellants statement of case at paragraph 20, Roman 1, it's accepted that the doctor's role, when considering possible investigatory or treatment options, is one that turns on clinical skill and judgment. Equally, once we've passed from that,
Montgomery shows that once the options have been identified, risks which would be material to that particular patient need to be outlined. By this stage, in light of Montgomery, one has passed from the test in Hunter. And for reasonable alternatives, the Council would expect that these should be discussed with the patient, absent, of course, compelling reasons not to do so. This case occupies the hinterland between Hunter and Montgomery. What is the position for a possible treatment known to the doctor, but deemed, as a result of a clinically defensible judgment, not to be reasonable in all the circumstances? Does that still need to be discussed? In this regard, the interveners consider that the practical realities of life in a medical practice or on a hospital ward need to be borne in mind. The risks of defensive medicine were mentioned in Montgomery. My learner from Mr. Weir says it would be quite unfair to advance such a line here. With respect, I don't accept that, nor do I accept the categorisation of this concern as in terrorem. Put simply, it would not be consistent with the regulatory objectives of promoting patient safety, maintaining standards, if doctors were required to outline the availability and the risks of all possible alternatives, even those thought in good faith and in line with standard and accepted medical practice, not to be reasonable in the particular circumstances of this case, or the case before the doctor. But here again, and I must stress this, there is no question of patient disenfranchisement. A doctor who arrives at a decision as to what is clinically appropriate for this patient without taking into account the circumstances of that patient is playing with fire. The patient-centred approach that I've mentioned requires no less. And it is, of course, important in any case, but particularly in cases before your lordships, to guard against the law of unintended consequences. It's very easy to focus intensely on the facts of this case, which includes something, on one view of it, as simple as taking ibuprofen, and to answer the questions posed in that microcosm. But I need hardly remind this court of the wider consequences of whatever it has to say on the issue. The practical day-to-day difficulties inherent in the appellant's case are illustrated by the assertion that whether or not an alternative treatment is reasonable is something that falls to be determined ex post facto by the court. As an initial response to that will not be so in 99.99999% of cases, which will never see a court. More importantly, to say that this falls to be determined by the court would leave doctors in practical difficulty, unable to foresee what a court might make of the matter. They might well be left feeling required to advise of all possible alternatives, whether or not deemed by them, responsibly and honestly, to be reasonable in all the circumstances. That would lengthen consultations in already busy wards. The appellant's case goes on, and here I'm thinking of the statement of case at paragraph 46, to suggest that a professional filter is unwelcome. The Council would respectfully suggest that such a filter is an important part of practice. Patients are often worried, upset, scared. An important part of acting in their best interests is filtering the options available to them. Removing that filter, inundating them with options, which the practitioner ex hypothesi thinks are unreasonable, is unlikely to be in anyone's best interests. And one might think that's what this court had in mind in Montgomery at paragraph 90. But at the risk of repetition, none of this involves proposing the arrogation to the doctor of the decision of what treatment to undertake. There is no question of a doctor only advising of treatments that she would recommend. If a treatment would be clinically appropriate and reasonable in all the circumstances of the given patient, it must be discussed with the patient, whether or not the doctor recommends or prefers it. But the logically anterior question is whether or not such an alternative is clinically appropriate and reasonable in the first place. Requiring a doctor to discuss options that are not just not recommended, that are not just not preferred, but actually thought not to be clinically appropriate, creates real difficulties.
Is there a difference between clinically appropriate and reasonable?
The BMA suggests that there is,
Yeah.
and one can see why that might be. There could be, as a matter of generality, amputation is not clinically appropriate for the flu, or for anyone. And I think what the BMA are getting at is they say, well, you start with that basic binary question of is it clinically appropriate in any case, and then you look at the particular circumstances of the case and say, is it reasonable for this particular patient? I'm not sure I would demarcate it in quite that way. I think it's definitely the case that one can say if it's not clinically appropriate, it will never be reasonable. You could advance an argument or theorise that something that might in the generality be clinically appropriate is nevertheless not reasonable for the particular patient.
But don't you consider clinically appropriate in relation to the patient?
Indeed. For myself, Lord, I see a cigarette paper between clinically appropriate and reasonable in the particular context that we are presently discussing.
For example, whether the patient is 5 years old, whether the patient is, say, 5 days old or 95 years old, might dramatically affect the range of possible treatments which were clinically appropriate.
Indeed so. Indeed so. And it's all, if we keep centering ourselves on that patient-centered approach, then many of these difficulties fall away. Yeah. But it is that distinction between something that is merely recommended and something that is reasonable that needs to be borne in mind. If we keep that distinction in mind, there is no question of the hollowing out of Montgomery. A submission itself might be said to be inter rem, because that submission involves an assumption that doctors would decide that the only clinically appropriate treatment is that which they would recommend. There are a number of difficulties with that. It fails to respect the professionalism of the medical profession. It assumes that such a decision would, if made despite obvious clinical alternatives, would be the subject of a supportive opinion from a reasonable body of practitioners. And it assumes that even if such an opinion could be found, that opinion would withstand an attack on the basis of Belitho or the advice of the Privy Council in Wong and Stokes. And as this court will recall, in Wong, despite the support of the entire legal profession of Hong Kong, the defendants were liable because the practice carried an obvious risk that could have been guarded against. one finds that in Bolitho itself. It's summarising Wong at page 2715 at letter H in the bundle. A doctor who is aware of other clinically suitable alternatives and who rules them out because she doesn't recommend them, put simply, will not be complying with the duty to identify reasonable alternatives.
And would you accept that that should be formulated as is or should be aware?
Yes, absolutely. Because that doctor, that hypothetical doctor, would not be complying with Montgomery itself at paragraph 87. A duty to take reasonable care to ensure that the patient is aware of any material risks involved in any recommended treatment and any reasonable alternative or variant treatments. So if a doctor just says, well, I'm recommending this and that's it, that doctor is not addressing the very thing that this court told her to address in Montgomery at 87.
So just to make sure, following up on the President's question, so you're saying that the alternative, clinically appropriate, reasonable treatment that the doctor must discuss with the patient will be measured not just by the doctor's actual knowledge, but what the doctor ought reasonably to be aware of.
Indeed. As with anything in this context, constructive knowledge would apply. So reasonable alternatives of which she was actually or ought to have been aware.
Yeah.
Yes. And just to see how that would work, I mean, if there were a school of thought, if the doctor had been brought up in a medical school in Edinburgh, and there was she was vaguely aware that there was a different approach in California, how would the doctor operate in that context?
Well, in that context, this would be Lord Hamlin's case, Juice, in which the question of whether or not the doctor ought to have been aware of that particular alternative would fall to be judged in my Lord's case on the basis of Bolam, in Scotland on the basis of Hunter against Ant. So if it was consistent with a reasonable body of medical opinion for a Scottish doctor not to be aware of some new treatment in California, then that would not be negligent. One needs to keep abreast of developments, but one is not obliged to be a seer, one is not obliged to be omniscient.
Well, I think Mr. Weir accepted that in his submissions. He was describing it as fairness to the doctor requires that you can't go beyond the actual constructive knowledge of the doctor. So, in a sense, you're supporting that.
Indeed. I mean, I think all parties agree that whether or not you ought to know of it falls to be judged on Hunter. But the appellant's case goes further and says that, well, once you're in that situation of actual or deemed knowledge, even if reasonably you might think it's not appropriate in this particular case, yet still you must discuss it. And that is the proposition that gives rise to the potential practical difficulties to which I've adverted.
Well, I wonder whether your formulation might also give rise to practical difficulties. It depends on the extent of the constructive knowledge that you are imposing on the doctor.
Yes. What's going through my mind is the bottom line is the whole point of Montgomery is what information should the doctor give to the patient, and we're told by Montgomery that the patient needs to be informed of reasonable alternative treatments. And one might think that the test of negligence would apply to in determining the range of the reasonable alternative treatments that ought to be discussed. Now, you might have a situation where you have a very well-informed doctor who reads every issue of the latest journals and is aware of a new technique being trialled at some cutting-edge hospital, perhaps. And he forgets to mention it. And another doctor who perfectly professionally has never heard of this treatment, and he doesn't discuss it with the patient either. Why should the former one be penalised for being better informed, albeit more absent-minded? I mean, if at the end of the day, what matters to the patient is how he is treated, and if he could be treated by a doctor perfectly properly in the way in which this doctor has treated him, why does it make a blind bit of difference that the better informed doctor knew about the treatment and everyone didn't?
Well, I think the answer to that would be found in the usual formulation that if one knows or ought to know something, then that triggers certain obligations.
Yeah.
Now, that may mean that the better informed doctor is under a stricter duty.
The point came up in a case I dealt with when I was an out-of-house judge, where it was to do with a circulatory problem, I think, in a patient's leg, and it would have been perfectly proper to amputate the leg. The surgeon attempted to save the leg by carrying out an operation which was unsuccessful, and he was then sued on the basis that he'd carried out the operation negligently. And if I remember correctly, while I found there had not been negligence, I added that I wouldn't have found in favour of the patient in any event, because it would have been perfectly proper for him simply to have amputated the leg, which is what happened after the unsuccessful operation. The leg then had to be amputated.
Yes. I think this discussion, if it points to anything, would point to a debate as to whether or not it's correct to take the position which all parties have taken thus far, that in asking whether or not the doctor is or should be aware of it, one judges that question under reference to Hunter and Bolam. Yeah. Because if this discussion means that actually the only question is whether or not you know it, regardless of whether or not you should know it, then matters take a different hue. For myself, and I think the council would take a similar view, it would be difficult to defend a situation where a doctor had negligently put him or herself in a position where she didn't know of something which she should know of. And that, in that scenario, it would be difficult to justify that just because you didn't know it as a matter of fact, the fact that you should have known it was irrelevant.
Yes. All that's going through my mind is that if the relevant question concerns whether there was negligence in the range of information that was discussed with the patient, then that's a point in time on which you ought to be focusing. And if you salami slice the process of decision-making on the doctor's part, which leads up to that point, you introduce, at each stage, you introduce the possibility of a finding of negligence, which would not exist if you focused on the stage which is actually, with which Montgomery is actually concerned.
Yeah. Absolutely, my lord. But it of course must be possible for there to be negligence at each stage. So I've described the starting point as diagnosis. If there is a negligent diagnosis, then everything flowing from that might lead to a successful claim. But of course, one can envisage a situation where the doctor tosses the hypothetical coin to find a diagnosis and happens to be correct. The answer to that claim is causation. It's not that there wasn't negligence.
Well, if there's a wrong diagnosis, you're probably not in the Montgomery realm at all. Montgomery is just concerned with the provision of informed consent.
Exactly.
But if it's a wrong diagnosis and you consequently are failing to treat the condition for which the patient is actually suffering, then that will be dealt with on conventional medical negligence principles.
Yes. So if we bring it back to the central question that is of interest to this court, of importance to this court just now, which is when we arrive at the Montgomery point where the duty to inform arises, is there to be this filter? Is there to be a professional judgment, one that's based on, judged on Hunter against Stanley, as to what are the reasonable alternatives? Or is it just, here is everything? In my submission, plain, simple logic suggests the filter is a good thing, because otherwise you're going to get into a position that has been mentioned in the court, and mentioned in the court, so I'm going to come to that very shortly, because it is this difference between, you can't just say, I recommend, therefore that's what's happening. That's a regress to the paternalism. In my submission, when the court looks at what Sheriff Collins said in Britain, the court will see, with respect, that is where the sheriff errs, because he conflates recommendation with the assessment of reasonable alternatives. I won't take the court to that, given time constraints, but if the court looks at what the sheriff said at 2738 to 2739 in the bundle, it shows that he was concerned that a doctor would confine what she told the patient to that which she herself preferred or recommended. That would be quite wrong.
Yes, so you say that the clinically appropriate alternatives are things which the doctor knew or ought to know, which objectively were proper treatments of the condition that had been diagnosed.
Indeed so. Indeed so. And there was some discussion of the case of Seni yesterday from the Albertan Court of Appeal. In my submission, when one looks at that, one sees a similar point to the one I've been making, made by Madam Justice Conrad, and I would just ask the court to turn this up. It's at page 3354 of the bundle. Paragraph 57, Her Ladyship says, the appellants argued that to overextend the duty to inform of alternative treatments places an unpredictable and monumental responsibility upon the medical profession, and one that is much too onerous. For instance, would it be necessary to inform of every possible alternative available, whether or not generally considered reliable? Would each professional need to become knowledgeable on and inform patients of alternative medicine practices, such as chiropractic treatment, holistic medicines? If the treatment performed complies with the local standard, why should it be negligence to fail to inform of another? And what she says about that at 58 is, that is a critical question, and the arguments against overextending the limit are compelling. So those are the concerns the Council has here. Madam Justice Conrad thought those concerns were compelling, but she didn't need to decide it in that case, because what she goes on to say is, the scope of the duty to inform must be approached carefully. However, whilst the breadth of that duty is important, this case does not compel a demarcation of its boundaries. Why? Because the alternative medical treatment procedure in this case was not a fringe alternative. So the whole premise upon which Seni is built is that there is a reasonable alternative that was not disclosed. It doesn't answer the question.
Well, but that obviously is the case in Montgomery too.
Precisely.
But my concern that I'm raising with you is once you say constructive knowledge is relevant, we are in the realms of addressing what the boundary of that constructive knowledge is.
I quite see that, although that's a concern that's one step prior to the concern that's in front of this court. Because the question here is, if you've got a hypothetical scenario where it's okay to exclude some matters as unreasonable in your clinical judgment, do you still have to disclose them to the patient? I think my Lord goes one step back from that and says, well, in a situation where there is no actual knowledge, should it be negligent to not know about that? I'm not sure whether or not that's a question that arises on this case, but I can well understand why the court would be concerned, given the breadth of what it's going to say.
But it is a separate question, isn't it?
It is a separate question.
It is, but I mean, there may be a scenario where a school of thought that is widely practiced in a particular jurisdiction considers that the options are X or Y. There may be a completely different school of thought in a different country, which is perfectly reasonable and perfectly respectable, but it might be rather onerous on the doctor if there are perfectly reasonable options in his country to brief the patient on something that isn't the practice in his country.
In that situation, if it's right to say that Hunter against Hanley governs both,
yes,
should I know and also should I tell,
yes,
there isn't a problem, because that hypothetical doctor will be protected by Hunter against Hanley.
So how specifically does the Hunter question relate to what you ought to know? What's the test?
Well, I think it was that was the test that was applied by the Court of Appeal in which my Lord participated in juice. And it was the question of whether or not one should know of a particular reasonable alternative falls to be governed by, as I say, under the law of England, Bolam.
So it's the same question as was being applied to the knowledge of risk at stage 1 in juice. You're saying
indeed
right here. But it does seem to me it is a separate question from what we're actually primarily looking at here. In effect, it's how far one's prepared to go over and beyond. If one was to reject the case put by the appellants, and we're in Bolam territory in dealing with reasonable alternatives, the question would then arise, and is it further, if you like, defence for the doctor that they may not know or might not reasonably have known of the reasonable alternative. So it's at that stage, I think, that one would arise at that.
Indeed,
and
so.
There may be arguments about that both ways, but it seems to me that even Mr Weir has said that it would not be fair at that point to impose liability on the doctor.
Indeed so, and I don't think anyone has sought to challenge the reasoning in juice. It is, yes, the reasoning in juice, which mapped onto the hypothesis that we're presently discussing would mean you would judge the doctor on the basis of Hunter against Hanley. And if, in the scenario painted by my Lord Hodge, in that scenario, that doctor is not negligent, because he's acting in accordance with an accepted body of opinion in his jurisdiction.
Can I ask you this? And it may be that you're coming to this, and don't let me take you out of your order, but the respondent's primary case has been that there is, if you've got to the situation of reasonable alternative treatments, applying Bolam, an obligation under Montgomery to discuss all those reasonable alternatives. Now, you'll be aware that in the BMA intervention, at paragraph 38.3, and that's at electronic page 3476, it appears to be suggesting that there is another filter that one might apply. And I didn't know whether there was anything you were intending to say about that.
I was, my lord, and just to go directly there just now, my understanding of that is that it must be a reference to what's said in Montgomery about there are potential situations in which you wouldn't disclose the therapeutic objection. Because it's difficult to see how, reading Montgomery, one could have, once one's landed at the point that my lord describes to me, so you have exercised judgment, you said, here are the reasonable alternatives. It's difficult to see in Montgomery what availability there is to apply a further filter if it's not based on that therapeutic objection.
Well, say, for example, and as I understand it, one question that was being thought of was, if you think about the particular patient, some patients may be extremely interested in the whole detail of what the options might be. Somebody else might be inclined, from the doctor's perspective, and reasonably so, not to be particularly interested in all that detail. Might there not then be a question as to how, so the question becomes, how significant is it to know of the risk for that patient? That is a question that Montgomery puts forward, and I think it's discussed by Lord Justice Hamlin under the question of risk. How far would it be significant for this particular patient? And that's what I rather understood 38.3 to be talking about. It says engage in dialogue about clinically appropriate, which I'm going to read as reasonably a reasonable alternative treatment, which the doctor is aware that a reasonable person in the patient's position will be likely to attach significance to, etc.
It seems to me is really just parsing what Montgomery said.
Yeah.
Yes.
You have to understand not just the risks that are generally apparent, but you need to have an awareness of the patient in front of you and what would be objectively important to a reasonable person in that patient's position.
So that patient is properly informed.
Indeed. Sorry, Mark.
No, sorry, carry on.
It's my lord and the chair's example of the opera singer and the procedure that might affect her voice.
Well, you talk about what would be important to a reasonable person in that patient's position, but Lord Barrows is, I think, focusing on the idiosyncrasies of the particular patient rather than the objective standard, saying that some patients may be inclined to accept the doctor's advice without going into detail, while others will want to know the details.
I think the BMA have effectively repeated in different words what was said in the last sentence of paragraph 87 of Montgomery, that the doctor is under a duty to take reasonable care to ensure the patient is aware of any material risks. The test of materiality is whether, in the circumstances of a particular case, a reasonable person in the patient's position would be likely to attach significance to the risk, or the doctor is or should reasonably be aware that the particular patient would be likely to attach significance to it. It's rather like the test of remoteness about the Pickford's delivery of the part for the mill, isn't it?
Yes, but it did seem to me that there was a difference between the way the respondents were putting it. That is, they were not, as I understood it, necessarily at least, accepting the additional filter, and the way it's expressed at 38.3. I mean, if it's being said that this is not really very controversial, and that Montgomery is dictating that 38.3 is correct, all well and good, but your position is that you are content that that is an accurate a way of thinking about it in 38.
If 38.3 is, as I would, and I would adopt this suggestion, if it is simply restating what's in the final part of Montgomery, then the interveners have no difficulty with it. If there's any suggestion of going back in any way from Montgomery, then I would not support that.
I mean, it's compressed. If you were going to accurately reproduce what was said in Montgomery, you would say engage in dialogue, providing advice as to the risks involved in those clinically appropriate treatments, etc.
Yes. In my submission, if it is correct, and I'm sure it is, because if it was going to be more iconoclastic than I think it is, one would expect to have seen it fleshed out in more detail. If it is simply trying to summarise what Montgomery says, then I have no difficulty with it. I think just two very brief final observations. Dealing with the AH case, that's Lord Boyd's case that was applied in the outer and the inner house, and the concern a doctor might find himself in a position of discussing treatment options that he thought were not reasonable. Well, the court will see that is part of the intervener's concern as well. The appellant's answer to that is that the threshold that the alternative treatment be a reasonable one should avoid putting the doctor in a position of having to provide treatment that would put her in breach. Well, that may be so, but it involves looking at everything through the retrospective scope that all lawyers and courts enjoy as part of their armoury, but which doctors lack when they're looking at patients. The central quick concern is, how does a doctor know what reasonable options to discuss if that question is governed other than by clinical skill and judgment? Now, I should stress in closing that nothing that I have said involves any attempt to advocate a retreat to the world of medical paternalism, or any attempt to dilute the import or impact of Montgomery. And in that regard, it might be of brief assistance to consider the difficulties that led to the change in Montgomery. The problem with medical paternalism is that, having arrived at a menu of clinically appropriate treatments, the law pre-Montgomery left it to the doctor to tell, or to decide, what to tell the patient about the risk-benefit analysis of each. And oftentimes, as Lord Burroughs remarked, that left the doctors telling the patient very little, if anything. And that was unacceptable because it didn't respect patient autonomy or bodily integrity. But the present case is one step before that. What is clinically appropriate? What is reasonable? It does not interfere with patient autonomy to leave that to the doctor in light of patient interaction, as it is a question of clinical judgment, and as otherwise one is discussing alternatives that are ex hypothesi unreasonable. In closing then, an indication of what the Council would consider necessary from the point of good medical practice. Firstly, a diagnosis, a clinical judgment that must be arrived at competently and professionally, taking into account all relevant information, in particular that derived from the patient. Next, an assessment of options to treat. Again, a clinical judgment that must be arrived at competently. An approach which ignores the particular circumstances of the individual patient would not meet the requirements of good medical practice. But ultimately, assuming the doctor has done what she must and then gathered all relevant information, including by way of proper discussion with the patient, it is for the clinical judgment of the doctor what alternatives might be considered to be reasonable. A requirement to discuss all alternatives, even if considered clinically unreasonable, would not be compatible with good medical practice or with the regulatory objectives. That is not to say, I should stress, that an assessment of what is reasonable is impregnable. It has to be a rational one arrived at by logical deduction. The doctor will have to be able to show her workings. An assessment of the alternatives which does not proceed on a proper assessment of the individual patient, taking into account their individual needs, would be unlikely to be defensible. Once those reasonable alternatives have been identified, we pass from the realms of clinical judgment and into that of patient autonomy. Montgomery, the 2020 guidance make it clear at this stage, all reasonable options, together with their risks and their benefits, need to be discussed. That is what the GMC would expect.
All reasonable options so identified by the process that you've already discussed.
Indeed.
Yeah.
That is what the Council would expect from the point of view of good medical practice, and I hope it is of some assistance to the Court in grappling the important issues that arise. The final point, I should say, on which I have no locus, but as my Lord and the Chair asked about it, is the question of the remit to the Lord Ordinary. That is something that is commonplace in England. CPR 52.20 2C expressly permits it. It is not the practice north of the border, and indeed in 2 recent cases has been described as incompetent. And I think those were the cases that my Lord may have had in mind when he asked the Scottish Council for observations yesterday. The most recent case is actually a medical negligence case itself. McLeod's legal representative against Highland Health Board reported 2016 session cases at 647, and it's paragraph 158 onwards, where the court discusses that point. That was an extra division. It followed the previous decision in a case called Sturton and Anderson 2 years previously.
Yes, that's a very well-known case.
Indeed so. Messrs Sturton and Anderson being very well known to the courts.
Yeah.
Well, Lords, unless there's anything which I can further assist, those are the submissions for interveners, and again, I'm grateful.
Thank you very much, Senior Secretary. Yes, Mr. Weir.
All right, please, my lords. If the test is as proposed by the outer house, the inner house, and the respondent on its reformed case, which is a withdrawal from Bolam Plus back to Bolam, then the position is as follows. First of all, a doctor may know of a treatment option 5, and that other responsible doctors support this treatment option. But because the doctor herself, supported by a responsible body, does not consider it to be a reasonable treatment option, the doctor is not obliged to disclose that treatment option to the patient. That is the consequence of the pure, unalloyed application of Bolam to the question of reasonable alternative treatments. And that, respectfully, is not good for patient choice. And the tenor of the observations from the court thus far, rowing with the tide of Bolam and against the tide of Montgomery, are observations that I would strenuously invite the court to reflect long and hard on before reaching its final landing point, because the consequences of so doing are extremely significant when it comes to the core issue of patient choice. Why, one might ask, should that patient not be informed of treatment 5? The doctor knows it's there. The doctor doesn't think it's reasonable, but the doctor knows that other doctors think it's reasonable. It may be the treatment option that this patient wants. And for my part, I understood Montgomery to go, as my Lord Reed says, to informed consent. And what sort of informed consent is that? Secondly, this situation will arise. The court may consider, if asked, that treatment option 6 should have been given to the patient as a treatment option, because it's an option that a reasonable person in the patient's position would consider significant, borrowing the language of Montgomery in paragraph 87. But there's no obligation on a doctor to disclose this treatment option because the doctor didn't consider it reasonable, which is the same as clinically appropriate, in line with the responsible body of doctors. That's my understanding of the effect of the observations of my Lord Burrows this morning, which is not going down by filtering down, but the concern that you have filtered down by the prior application of the Bolam test. Because there you've got a situation, if you honour and respect Montgomery, and you understand that it's the starting point of your analysis, the moment you're into information. The information is with the doctor. The information is not with the patient. It's an information transfer or highway. And what's being proposed is that highway is blocked. And treatment options are never taken down the highway to the patient. So here's a situation where, applying Montgomery, you can go for a specific patient with specific issues. The court says this patient would want to know about this treatment option. That would be the court's assessment, but it doesn't matter, because the doctor simply says, I was acting in accordance with a responsible body of medical opinion in not disclosing that to the patient. And if the raw, unalloyed application of Bolam is the decision of this court, that is the outcome, and that is also not good for patient choice. The third position is a doctor can exclude information from the patient as to alternative treatments, provided simply that the doctor, supported by a responsible body, considers the alternative treatment is not clinically suitable. But it is not an issue of clinical assessment alone. And in Australia, in the landmark case of Rogers and Whittaker, which I'll just invite you to turn up if I may, at page 3332. (3332), please. Paragraph 14. And about the middle of paragraph 14, just below the middle, I'm going to pick it up. Whether a medical practitioner carries out a particular form of treatment, no, my Lord, see that. Thank you. In accordance with the appropriate standard of care, is a question in resolution of which responsible professional opinion will have an influential, often a decisive role to play. Whether the patient has been given all the relevant information to choose between undergoing and not undergoing the treatment is a question of a different order. Generally speaking, it is not a question, the answer to which depends upon medical standards or practices. This is the information. Information equals alternative treatments and risks. It is not limited to risks. And the whole point, as I have understood Montgomery, and my respectful submission would urge this court, when carefully rereading Montgomery to understand it, the whole point of Montgomery is that relevant information is not bounded by clinical judgment. It should be centred around what the patient would consider significant, which is absolutely not the same thing. The next consequence is that Webster in the Court of Appeal must have been wrongly decided. And the court will need to overrule it in my respectful submission. After all, the doctor, supported by an expert called by the NHS, reasonably didn't think it necessary to advise the patient in relation to the benefits of labour by induction. So that's applying Bolam. There was no need to go there, so the decision must be wrong. So the Court of Appeal, carefully understanding the full impact of Montgomery, and see the High Court decisions following that, were all mistaken. Montgomery never did all the things that we thought it did. It's a much more limited effect judgment than has previously been understood. That's the position if this Court of Appeal says, if this court says it's unalloyed Bolam. And even, fifthly, the Juice judgment is seriously undermined. Now, there was an exchange yesterday between my Lord Burrows and my learned friend, which might suggest that the respondent agrees that the Juice approach could be transcribed across to alternative treatments. In other words, for risk, read alternative treatment. That was certainly my understanding of the effect of the exchange. And that, as this court knows, is our case. But the respondent's case does not allow for this at all. The respondent's case has no second stage. There is no second stage. We've heard it articulated clearly. The position is simply, as the doctor considered an alternative treatment to be a reasonable alternative treatment, if so, it's disclosed. If not, it isn't. That's it. That's Bolam. That's how it applies on the respondent's case. No more, no less. So it's only one stage. But this will also have a serious impact on the disclosure of risk. And Juice was a case about risk. And if we go back to Juice, please, to paragraph 35, which is at page 2835. Lord Hamblin said, factors of relevance in determining materiality, and that was materiality of risk, include, and the last in the list, the alternatives available. The two are necessarily interlinked. So if, therefore, the doctor has opined that there is no reasonable alternative, which is application of Bolam to reasonable alternatives, and the doctor says there's no reasonable alternative, and no need, therefore, to disclose this possible alternative, then what of the duty in relation to the treatment that's recommended, in relation to its risks? If you go back to Webster, the issue in Webster is, if you leave the baby inside the mother and allow birth to take place when it takes place, there is a risk of damage to that baby. The solution, brackets alternative treatment, is induction of labour. Well, if the court hears evidence, as it did in Webster, that that is reasonably not a risk and or, let's for these purposes see, alternative treatment, then you don't need to mention it. So if you then go back to what is happening, you don't need to mention the risks associated with polyhydramnios, asymmetry of frame and small gestational size. Because there's no need to mention a risk when the risk only goes to the issue of the alternative treatment. The risk is meaningless otherwise. If you go back to Montgomery, why reference the risk of shoulder dystocia unless you also reference the alternative treatment of caesarean? It's meaningless if you've got a risk of shoulder dystocia, but there's no suggestion of an alternative. It doesn't matter. So actually, when you analyse this right down to its bare parts and the real consequences of the application of Bolam at this so-called described logically anterior stage, which looks naturally to be clinical judgment ergo Bolam, it just doesn't work. So you'll end up with undermining the risks advice in relation to the proffered treatment option, which is antithetical to Montgomery 87. That's the difficulty in our respectful submission with what apparently on its face seems like a very natural submission for parties to make, that really we're just dealing here with clinical judgment which must be Bolam.
Is that right? If there's always an option of no treatment, aren't you going to address the risks of the treatment?
No, my Lord, you're not going to give an option of no treatment if reasonably, in accordance with Bolam, you don't need to give the option of, say, no treatment. Doesn't matter. You're governed by Bolam. Bolam will control what the doctor should say. Once the doctor then doesn't have to reference whatever alternative options there are, it's going to necessarily unravel the content of the duty to advise in relation to risks as to what is left. And see the examples that I've just given. That is why, in our respectful submission, the correct approach is there will be a range of treatment options, risks associated with those, and the first filter is the filter of knowledge. And this is exactly how it is set out by my Lord Hamblin in Juice at paragraph 33.1. And if you've still got that open, it's page 2835. And this is on the basis that we are entitled to transpose alternative treatments for the words risks. So what risks, or I would then say alternative treatments, were or should have been known to the medical profession in question. And we accept that is the appropriate first stage test at that point. But after that, the question that you're asking is the question for the court to answer, because it is only by the court answering it, when the court is respecting patient values, that the patient is given true patient choice. And the consequences of that were well understood by the Supreme Court in Montgomery. So if we can kindly just go back to opening up Montgomery. That's page 3024. Which at the top, in part of paragraph 92, but you can read it if you like from page 3023, picks up arguments that can be made against what the Supreme Court did in paragraph 87, including the last one, that the requirements imposed are liable to result in defensive practices and an increase in litigation, and that the outcome of such litigation may be less predictable. And if you drop down to E at paragraph 93, please. In relation to the fourth point, we'd accept that the departure from the Bolam test will reduce the predictability of the outcome of litigation, given the difficulty of overcoming that test in contested proceedings. It appears to us, however, that a degree of unpredictability can be tolerated as the consequence of protecting patients from exposure to risks of injury to which they would otherwise have chosen to avoid. The more fundamental response to such points, however, is that respect for the dignity of patients requires no less. That is very powerfully worded, because in Montgomery, the Supreme Court absolutely understood what the core issue was. And a row back, this would be nothing less than a row back from Montgomery, if the court now says, well, I'm very concerned because actually the poor doctor can't make an assessment as to what alternative treatments the court will consider reasonable. The whole point of Montgomery is the Supreme Court recognised that the doctor has to, if you like, in that sense, predict what the court will say in relation to risks, because it was not a doctor-based test. It was a court-based test respecting patient values. So that is a consequence, fully understood, overtly understood by the Supreme Court, which it accepted as a necessary consequence of the fundamental response to respect the dignity of patients. And what instead we have, as per my opening submissions this morning, is a series of situations in which one can see patients being limited as to what it is that they're being told about in the first place. all controlled by the doctor. And it may be said, that's not medical paternalism. Medical paternalism is something else. But it's wrong. That's medical paternalism. It's exactly what that is. That is a row back. So one starts with that question of knowledge, and Saney echoes that. That was page 3356. It's reference to known procedures. So it's not a question of knowledge as to other responsible practices, which was, I believe, the respondent's case at one stage. It's not that. It's just knowledge of known procedures. And then it's a matter for the court to assess, which obviously takes into account medical opinion. And so if a doctor comes and explains how it is that she made her assessment, that may be very powerful evidence for the court when making its assessment as to whether that is an alternative treatment that this or a reasonable person in the patient's position would have considered significant. And that will be workable as we see it has been workable in Webster and other cases. Otherwise, we're in a position which is echoed out in this particular case, where Dr. Labinger is able to say, I didn't consider non-steroidals to be clinically appropriate, with the result that the option of taking ibuprofen is not even mentioned to the patient, when it's the standard treatment for pericarditis, which it's agreed the deceased had at the relevant time. So this idea that Bolam is not super restrictive is respectfully entirely misplaced, that Bolam is somehow going to allow the menu to stand at a high level of generality is not how it works in practice. See Webster, see this case. And Dr. Labinger didn't make the assessment because the correct step in her view was to treat the underlying condition. That's what we were told yesterday, said to be lower respiratory tract infection. Can I just address, I'm now moving from the law back to this case, can I just address that by saying we respectfully simply don't accept that as an accurate description of the evidence in this case. If you kindly go to the SFI at paragraph 67, page 78, page 78, para 67, down near the bottom, you'll see it says, this was not a straightforward case of acute pericarditis. The diagnosis remained uncertain. That's the position. It was idiopathic. It's not the case that it was, oh, we understand this has been caused by a lower respiratory tract infection at all. And when you go to the note that Dr. Labinger produced, and here you can go to the outer house opinion at page 224, please. (224) at the top. So we're in para 28 of Lord Tyer's opinion, if the court has that. And that's the note produced by Dr. Labinger. It doesn't say lower respiratory tract infection. It ends up saying, I'm not certain where to go for a diagnosis from here. So it's common ground there was pericarditis, but it was idiopathic pericarditis. And going back to the literature, and I'll just give you the reference, page 1069. In the usual case of idiopathic acute pericarditis, treatment with any of the non-steroidals usually suppresses the clinical manifestations in 24 to 48 hours and frequently more rapidly. And this is a case, just to re-emphasize this, in which the deceased had been readmitted to hospital with chest pain. Page 71, if you can kindly go back now to the SFI at paragraph 40. The court will see paragraph 40, that his complaint, this is on the 1st of April when he's readmitted, was of chest pain. At the time that Dr. Labinjo saw the deceased, he was not then suffering from pain, but it was an acute presentation with chest pain and with pericardial effusion. He had symptomatic pericarditis. Furthermore, if you kindly stay in the SFI and go to page 73, paragraph 48, the third echocardiogram, which was that on the 2nd of April, see para 44, the day before Dr. Labinjo's reassessment. I hope I'm not going too fast. And then if you're in para 48, for Dr. Weir, the crucial matter was a trend. The third echocardiogram showed a deterioration from the second one, in that the effusion appeared to be larger and there were early signs of compromise of the right atrium and right ventricular wall. So actually, what's painted as, oh, this is just treat the lower respiratory tract infection, is actually idiopathic acute pericarditis. Coming back in for chest pain, on the 2nd of April, the third echocardiogram shows more of an effusion than there was before. And this growing condition was the condition he died from. And he was never even told of the standard treatment. Hasn't something gone wrong with the legal test? If somehow patients can be in this position with acute pericarditis, you go to the standard textbook, you go to the ESC guidelines, it's treat with non-steroidals. And the ESC guidelines I've referenced at page 1019, should this court have the stamina and enthusiasm, we would certainly ask that it has regard to the whole of the guideline document. It's not that long, but I do understand there are limitations on what the court will sometimes be able to read.
What page number?
It was 1019. I've given it before, my lord.
Thank you.
And not only was it the standard practice, Dr. Labinjo knew it was the standard treatment because it was advocated in the textbooks. That's the SFI at paragraph 64, page 78. And had he said, at that moment in time, I've got pain, she would have prescribed non-steroidals. So it's a super specific basis for saying it's not clinically appropriate, that he wasn't in pain at that particular point in time. And just standing back and trying to understand what the whole purpose of this debate is about, which is to provide patient choice. Isn't that exactly the scenario where you as a patient would want to be told, by the way, I don't think that non-steroidals are going to help because you're not in pain at the moment. But all the textbooks and the ESC guidance says treat pericarditis with non-steroidals. It doesn't say treat pericarditis with pain with non-steroidals. It says treat pericarditis with non-steroidals.
Was that Dr. Weir's understanding?
My lord, yes.
I thought his evidence, as presented by the respondents, was that he wouldn't prescribe NSAIDs unless there was pain.
My lord, that's respectfully, that's a different point. That's the issue of treatment recommendation, as in I recommend this treatment. We've moved from clinically appropriate just means what I recommend, to looking at a recognition by the respondent in the GMC that clinically appropriate means all reasonable alternatives. Whether a doctor, one particular doctor, says I would recommend this or not isn't the issue. Yeah. Once it's understood that it's an issue of patient choice, shouldn't the patient be entitled to make the choice? Here is a treatment. I don't think it works because you're not in pain, and I think it's for pain, but the textbooks will say it's treat pericarditis with non-steroidals. By the way, the downside of this is you might get gastric upset for which you can take more tablets. The upside is you treat your pericarditis, the very thing that killed him. That's what this case is about. It's about patient choice and respecting patient choice, real terms. In real terms, you cannot slip in bolum. You will simply limit patient choice. This case is a paradigm for that. In relation to the issue of causation, if I can go to that, please. The business of what it was that was put before the inner house as an outsider looking in, the non-Scottish practitioner looking in, it seems, sorry, proceed with caution, my lords, but it seems to me entirely unfair to characterise the appeal as not being put on a full and proper basis. We've included in the email which was sent this morning, and it will arrive at some point.
It has.
Oh, I'm very grateful. We've included my learned Silk's note of argument on behalf of the pursuers and reclaimers, and if the court kindly goes in either now or in due course to 7.22, 7.23, which starts at page 29, and then essentially the whole of 8, which starts at 30, does, by the way, include reference to Shenbury and Marshall, and I think it was said yesterday there was no reference to Drake and Harbour, but it's all there. And we will also, if we may, send you the grounds of appeal, all of which make absolutely apparent, so far as I interpret these documents as an ordinary lawyer, absolutely apparent that there was a full-on challenge or a full-on request, if I can put it that way. I say because there weren't findings of fact below. There weren't findings. That's common ground. The Outer House did not make findings on causation. So we're not appealing findings. But para 8, page 30 starts, the Lord Ordinary erred in fact and in law in his approach to the causation question of whether Mr. McCulloch's death would have been prevented. The issue was squarely before the Inner House, making paragraph 60 of the Inner House's opinion and the document that they produced when refusing permission requiring of careful reading.
There used to, when I sat there, I don't know if the position's the same now, but there used to be a rule of practice that if you were asking the Inner House to make findings of fact, you had to put forward in writing what the findings were that you were proposing they should make.
I know it can be a bit of a bombardment issue, but what I'm going to ask permission to do is to allow my learned friend to produce such relevant documents as can hopefully persuade this court that the proper steps were taken below. And then my Lord is then going to look at the PTA that I drafted, which gave me permission, which certainly, as an English lawyer, seemed to me entirely to satisfy the requirements, but which were to say, causation's an issue, we'd like to win on causation, please, failing which we'd like it remitted to the Outer House. So for this case to fall on some respectfully false procedural hurdle doesn't seem to me to be doing justice between the parties. In relation to the issue of causation, at one stage yesterday was an observation by my Lord Hodge on the basis that the pursuers didn't come up to proof, or words to that effect. And this is where, in our respectful submission, Drake and Harbour comes in, because it's the wrong way round to look at it as the pursuers didn't come up to proof. The right way round to look at it is the courts draw the inference that the damage which was in the arena of risk caused by the breach of duty is damage which occurred as a result of the breach of duty. That is not, certainly per Lord Justice Longmore, an issue of res ipsa loquitur. And if the court can kindly go to page 3463. 3463. So 3463, we're back into Drake and Harbour, and that's after Lord Justice Longmore, as your lordships will recall, at para 15 had dealt with what we now call Drake and Harbour. That was his para 15, and then he has a heading before para 20, res ipsa loquitur, and he then says it's therefore unnecessary to consider whether the judge was entitled to rely on this maxim, and I won't read out the rest of paragraph 20. So, very respectfully, I would certainly invite the court to approach Drake and Harbour as Drake and Harbour and not as merely an application of res ipsa loquitur. There are cases on res ipsa loquitur that I've not put before the court. I've not really gone to analysing res ipsa loquitur because it was the first time that it's been proposed that we might just be looking at res ipsa loquitur is from the observation, I think, this morning from my Lord Hodge. And so then I would rather ensure, if the law was going to go down a certain path without any submissions in relation to it, that we were given the opportunity to make further written submissions in relation to it.
The particular facts of Drake were very striking, because there was absolutely no other explanation for the fire, was there?
Well, my Lord, Drake, as I've been at pains to set out, Drake and Harbour, when one goes to paragraph 28, doesn't say there can't be other explanations. It says, if the damage is, and I use the word liable, that damage that's liable to be caused by the breach, the court can infer as a matter of common sense it was. And then there can be explanations. So Drake and Harbour isn't about this was a compelling case on its facts. So we never get to that. That would be a case that simply said it's not an inference. You're just literally obliged to win because no evidence was adduced. Drake and Harbour is at an earlier stage when it says the starting point for the court is to draw this inference. And the other cases which go through Drake and Harbour are cases which we've put into a bundle, electronic bundle, which we've sent to the court. Of course, some of them don't. Some of them don't refer to Drake and Harbour because they're before Drake and Harbour, and some don't because they don't. But the principle is the same, whether it's referencing Drake and Harbour or not. Can I just give the references by way of the page number? We've given you a paginated electronic bundle of these cases, and rather than you rooting around looking for the relevant passages, can I give the passages? So the first case is the Roadrunner case, and it's page 8, para 29. The second case is Levicom, and it's very pithily put by Lord Justice Jacob at para 284 at page 77. Just one tiny paragraph. That is, we say, another application. The next case is Vale and London Borough of Havering, page 86, paragraph 32. Then there's a case called Pethy and Hubble, and that's two judgments. Page 107, paragraph 89, per Lord Justice Tomlinson, who actually talks about the burden being on the defendant. This is a case where the claimant's hit in a road accident, and had the defendant not been careless, the claimant would still have been hit but at a slower speed. And you could say, well, there you go. Now you've now proved that being hit at that speed rather than the slower speed has caused you the damage of which you complain. But the Court of Appeal adopted, again, what can only be described as a robust approach. See para 89 per Lord Justice Tomlinson and para 90 per Lord Justice Longmore. Where he says, in the middle of 90, the injury which occurred was of a kind likely to have been caused by that breach, see Clark and Lindsell. In these circumstances, I don't consider it necessary for the claimant to prove positively the negative proposition that the accident would not have occurred if the defendant had been going at safe speed. Realistically, it should be for the defendant, who's already been found to be in breach of duty, to show even if he had been driving at non-negligent speed, the accident would still have occurred. Then there's a case called Sobolewska, which is a first instance case for which the reference is page 127. Page. I think this one is page 110. Paragraph 8, Mr. Justice Foskett referencing Drake and Vale. Then there's a case called Anandi with Mrs. Justice Yip. Page 127, paras 39 and 40, and at para 40, this is page 127, The appellants approved the respondents were in breach of duty because it failed to respond adequately to the October thefts. By not getting to the bottom of the issue and considering what should be done to overcome the breach of security in its own hotel, the respondent exposed its guests to a risk of loss, because it's all about that risk. If the respondent wished to argue nothing more could reasonably have been done, it could have called evidence, etc. And then the last case is a case called Goldscheider in Royal Opera House. And there's analysis of some earlier Court of Appeal cases. The whole thing starts at page 153 and runs through to 155. And at 155, in the joint judgment of Lord Justices McComb and Bean, so 155 para 69, in the present case before us as in Gaith, the claimant has established the occurrence of the risk inherent in the activity which he was carrying out at this rehearsal, namely the excessive exposure to noise. It's hard to see that this rehearsal was merely the occasion for the injury and not the cause of it.
So is there any discussion of this approach in the textbooks or in case notes?
Clark and Lindsell, very short. It's like almost it's a footnote. When I put Drake and Harbour back in last night, it was a footnote. But there is a reference that I've given you just earlier to that passage in Clark and Lindsell. And if my Lord would find it helpful, we can send.
You don't have the reference to hand?
I have the old reference from an early case, but which I think was 207. I think I just read it out. But,
if you could send the extract,
I'll send any extracts I've got, Drake and Harbour.
Thank you very much.
My Lord, yes. From Clark and Lindsell, we can look in Charlesworth and Percy if you'd like as well. See if it's something that might or might not be. The final issue, which was going, I don't have time to make submissions, just to cover off, was the evidence of the impact of non-steroidals, in which the language used by my learned friend against the document that we've created is fairly brutal in its description of misdirecting and misleading and all the rest of it. And I try to move away from that sort of criticism as much as possible, which I really take to be somewhat unfair. But what I invite the court to do before simply accepting this sort of very strongly worded criticism is actually just to go back what we have drafted, and which I consider to be entirely fairly put. But it's all set out. I gave you the references. It really starts at page 115 and goes to 119. What there was in this case was actually quite a lot of agreement between Dr. Flappan and Dr. Bloomfield as to how non-steroidals were the mainstay treatment, and patients got better when they were prescribed. And we've set out that part of Dr. Bloomfield's evidence at para 105, page 118. And indeed para 106. So, my Lord, I'm extremely grateful. I've probably gone slightly over the 30 minutes. I'm very grateful for your Lordship for allowing me to do that. And unless I can assist further with yet more documents that will be sent through electronically, those are our further submissions, my Lord.
Yes. Thank you very much, Mr. Weir. Well, as I think we've made clear during the course of the hearing, we recognise this is a very important case in the law of medical negligence. We'll now take time to consider all that we've heard, and we'll let you have our judgment in due course.